Often take the freedom of association for granted, but what about the freedom to not associate? As odd as it may sound, it's the freedom to not associate that has recently come under attack. And that's why Senator Rand Paul and Congressman Joe Wilson recently introduced the National Right to Work Act in the U.S. Senate and the U.S. House of Representatives to protect individual workers from unions that seek to bully them into either joining their ranks or sacrificing a chunk of their paycheck as a tithe. In 1963, the Supreme Court ruled in National Labor Board versus General Motors, the unions have the ability to extract money from the paychecks of non-union workers in workplaces that have unionized. This practice has become widespread, and non-union workers forced to pay these dues are often called financial core or FI-core workers. On February 4th of this year, Democrats introduced the PRO Act, which, among other things, would force workers in unionized workplaces across the private sector to pay union dues, whether or not those workers want to be part of a union. We could see that right-to-work laws are directly under assault. Public sector unions have already lost on this issue in the Supreme Court in Janus versus the American Federation of State, County, and Municipal Employees. This case ruled that government unions can't force non-union workers to pay union dues. But these protections do not extend to the private sector. This is why states need to pass their own right-to-work legislation in order to protect those rights. The National Right to Work Act would extend right-to-work protections to all 50 states. Joining me now to talk about this important bill from the National Right to Work Foundation is Mark Mix. Welcome, Mark.
Good to be with you, Chris. Thanks for the opportunity to talk about this bill.
Thank you. So the economies in right-to-work states like Arizona, Texas, and Florida have seen tremendous growth in recent years. Now contrast that with states with powerful unions like California, which have seen economic stagnation. How would the National Right to Work Act bring some of the same benefits we've seen in right-to-work states nationwide?
Well, Chris, the first benefit of the National Right to Work Act, as introduced by Senator Paul and Congressman Wilson, is the fact that it gives individuals the free choice to decide whether or not they want to support a private organization for their right to work. Unfortunately, under the federal law that's been in place since 1935, workers can be fired from their jobs for failure to pay dues or fees. And it's only the right to work laws in 27 states that stand in the way of them being fired. But here's the second point. From an economic standpoint, you're exactly right. Those states that have right-to-work laws have been deemed the best for business year after year after year by folks that look at these things. And manufacturing companies looking to expand or relocate want to basically go to right-to-work states. In fact, we know that 50 to 75% of all companies looking to expand or relocate or create jobs across America will only look at those states that have right-to-work laws. And so when we talk about forced unionism and reapplying it back to the entire country, it will be a hit and a drag on the economy as well.
And in the wake of these lockdowns, that's more of an issue than ever. So I want to talk about some of the political implications of right to work. The Supreme Court ruled that union members are able to opt out of paying dues that go to political spending in the Beck ruling. But talk to me a little bit about the ways that unions get around that and the massive amounts of money that unions pour into the political system.
Well, Chris, in your introduction, you mentioned the Janus v. AFSCME decision. That was our case at the National Right to Work Legal Defense Foundation. We argued that case at the Supreme Court. And basically, we argued that this forced payment of fees to work for your own government was a violation of the First Amendment. And fortunately, a majority of the Supreme Court agreed with us. So we do have right-to-work protections for every government employee across the country at every level of government. But as you mentioned, it doesn't translate into the private sector. So in the private sector, basically, workers can, in the states that don't have right-to-work laws, the 23 states, they can be forced to pay a certain set of fees in order to keep their jobs. And this goes back to a 1988 case that we won at the U.S. Supreme Court, a case called Beck versus Communication Workers of America, again argued by the Right to Work Foundation, where we actually protected private sector workers from the forced payment of dues or fees that are used for political or ideological causes which they disagree with. You know, it's outrageous that someone could be forced to pay a fee, watch that money be used on a political candidate or a political cause they disagree with, and if they disagreed and said they didn't want to pay it, they would lose their job. But, you know, union officials have ignored the Beck decision for years and years and years. In fact, we have a case right now, a case that's been going on for about 9 years up in Rhode Island on behalf of an employee who was trying to exercise their rights under the Beck law. And union officials basically hide their expenditures. They hide their expenditures and say, well, this isn't necessarily politics or ideological causes. They try to make it under necessary or what they call, you know, the functional costs of unions. We have to litigate those cases, unfortunately. And union officials, while they're supposed supposed to give an independent audit to workers and show them where this money's going and what money's used for contract negotiation and grievance presentations. Otherwise, they can't prove it. And in the Beck case, when a special master looked at the expenditures of the Communication Workers of America, the union could only prove that 19 cents on every dollar was used for anything that resembled kind of union representational causes. So it's still a fight. There's protection there. But ultimately, we want to get to the First Amendment for all private sector workers, too, and get protections for them across the nation.
And I imagine many of the workers in these states without right-to-work protections have been paying into these systems for years and years. If this law were to pass, is there anything that these workers would be able to do to get a little bit of that money out of the system and back into their pockets?
Well, that's a great question. And unfortunately, for a worker to exercise their rights, their Beck rights under the private sector law, they have to resign union membership in order to uphold their kind of ideological or political rights. Unfortunately, when they resign from the union, they can't vote on the contract that governs their employment. They can't vote in union elections. They can't participate in any kind of union activity inside the workplace. For example, being on a committee or anything like that. They have to forfeit their workplace rights in order to protect their political and ideological rights. That's a Hobson's choice that workers should not be forced with. And as you mentioned, back in 1963, the Supreme Court ruled in General Motors, it used to be from 1937 to 1963, workers could be literally forced to join a private organization in order to work in states that didn't have right to work laws. The Supreme Court said that's a bridge too far, and they said, well, we can force you to pay up to 100% of dues to keep your job, but we won't force you to formally join the union. That's not really relief for anyone. The real relief is saying you have the choice, and that's what the National Right to Work Act would do. It's a simple one-page bill, doesn't add a single word to federal law. It simply says that the bias in the federal labor policy that governs the entire country is in favor of voluntarism and not compulsion. Real simple stuff.
And quickly before we go, talk to me about the PRO Act that was recently introduced by Democrats and some of the damages that could bring to the economy, specifically some of the AB5 protections that we saw, or AB5 regulations that we saw in California going nationwide. Yeah, that's exactly right. The bill is going to be on the floor of the House next week, according to Steny Hoyer, the majority leader. And the bill is basically the first and foremost priority of that bill is to repeal all 27 right-to-work laws across the country. That's issue number one for organized labor and for the sponsors of this bill. They want to eliminate a state's right to have a right-to-work law or even pass one in the future. Secondly, they're imposing some of this AB5 stuff from California, as you mentioned. This is the idea of eliminating independent contractors, and it's primarily targeted at gig employees, the kind of Uber, Lyft drivers, journalists who are writing, pieces for various magazines and internet content. And basically in California, it was a disaster. Most of the progressive leftists were opposed to it because they were the ones that were kind of participating in this gig economy, doing lots of different things. And it immediately made them employees of the companies that they were, contracting with or doing work for as an independent employee and forced them into an employment situation which the company didn't want and many employees or independent contractors didn't want either. And so they're trying to export that problem from California across the country in this bill. It also includes a provision that would basically eliminate the card check, or would eliminate the secret ballot election and allow union officials to be certified by card check, which is a highly coercive and threatening technique that union officials have used because they can't win elections anymore. If they can get you to sign a card, they get you into the union. It has significant penalties for employers when even the allegation of an unfair labor practice comes up. It has binding arbitration. It has literally the federal government imposing contracts on private businesses across the country. It's really a smorgasbord of big labor desires for the last 40 or 50 years wrapped into one big package. Mark, thank you for joining us to talk about these issues.
My pleasure. Thanks for the opportunity.